Hey, hello everyone. And it's Tuesday. And you know what that means? We're going to be talking some true crime. Thank you for everybody joining in chat. All of you out there watching, lurking, buying, and all of you that are going to be watching later. I look forward to hearing from you all because tonight we have a lot to discuss. A lot to discuss. And everything we're going to bring forward is going to bring a lot of questions. And I look forward to hearing what you all have to say about it and what questions you may have. And, with basically, we should actually just get right to it. What do you think? First, let me just say hello to my mods. Thank you so much for being here. Hey, Rocket Couch, thanks again. Bingo link is up above if you want to get a bingo card to play for a bingo for every single stream. Just send it in to me with the name on it. Hey, Pete Hutchins. Go Bills. Yes, well, if you're a Bills fan, then I hope you're doing okay, Pete. I hope you're doing okay. And it's good to see you. Well, today we are going to be discussing, of all things, and I'm going to be a little tiny icon. But before I switch over, could I just get an audio check, please, from someone in the chat? I would like this to go too far in with the bad audio. Is it too loud? Is it too soft? Is it crackly? Is it anything? Oh, thank you, Pete. Thank you, Shill. Okay, so then, hey, Trees, thanks, and thanks for the ordering, everybody. Hey, Sean. Hey, Mitt. Good to see everybody. Ah, good. Oh, perfect is a great word. Thanks. Thanks, Mitt. Thanks, Pete. All right. See, I'm still with you. I'm just going to be an itty bitty little thing in the corner there because I want you to be able to see the presentation. Because today we're going to talk about the Bryan Kohberger case. This is the Idaho 4 out of Moscow, Idaho. It was the murder, homicide case of 4 Idaho students. And we're going to go over all of that. But I'm not doing banner tonight, maybe because it'll interfere with the presentation. But thank you. It's just going to be too much across the bottom. They won't be able to read. Oh, there were so many words in today's presentation. You'll see why in a moment, but I appreciate it. All right, so Bryan Kohberger is up for 4 murder charges and a burglary charge in Idaho. If you want to get caught up with the case, there is a link in the description for all of the coverage in from start to finish, because we've been actually from before he was even charged, we were covering all of this. But really, the reason that we're here today and that I'm going to dedicate the whole stream to this one case, which is unusual for us, is because on the 14th, Kohberger Defense filed 13 motions, 160 pages, to suppress all the evidence in the case. Yes, you heard me correctly. Yes, they did. Yes, they did. All the evidence. And we're going to have to go out. And you're probably thinking to yourself, as I was when I first heard the first headline in regards to this, how is that even possible to throw everything out? Well, it is definitely possible. And it's kind of convoluted how. And I know we're all going to have a lot to say about it. I know we are. Okay. So yeah, let's start at the start. Okay. First, let's talk about one thing that we're going to learn is the type of evidence that they do have against Bryan Kohberger. Now, all along we knew that, they had video of the Elantra, the Hyundai, the white Hyundai Elantra. We knew that they had the drop of DNA from a knife sheet. They had an eyewitness, the woman who lived in the home, in a statement about what she saw. Okay. But there's some other things that we didn't know that they had. These 13 case summaries Okay, this is from the case summary. They list everything all out on the Idaho site. And for those of you that are interested in actually looking at the actual documents word for word, which there's not going to be a lot. There's a lot of redundancy there. Here, as listed always in my description, is where to get the public documents in Idaho for this case. Now, I will warn you, all the juicy stuff we're not going to know about because Judge previously had submitted under seal everything in regards to the IgG genetic testing and the evidence and a lot of stuff in regards to actual the warrants and statements in that were done. Okay. But I can tell you that there is still a lot of information here that we can go. So try not to get frustrated. If I could tell you, I would. Okay, but we're just going to go over the issues and what they're alluding to, and then we're going to go over an order that the judge had already made, the tone of the judge, and we're going to look at some statutes, and we're going to try to understand where the defense is coming from. But I'm going to tell you straight out, first thing, that this was a lot of work. And just like with the death penalty, Ann Taylor just knocked it out of the park with the death penalty, that was 1,000 pages. This was only 160, but a lot of it was under seal, so we didn't get to see it. So that could be hundreds of pages more. I'm not sure, but at least I only had to read 160 pages since the 14th, which is not anywhere near as bad. But let me just break down what these motions to suppress covered, because there was an individual motion to suppress for each one. And they were the Pennsylvania search warrant for the home of Bryan Kohberger's parents, the Pennsylvania search warrant for the white Hyundai Elantra, the Pennsylvania search warrant for Kohberger's person himself, the Latah County search warrant of Kohberger's person himself, the pen trace and trace devices that were used for location in things like that in Idaho, the Google search warrant. This is new. They have his Google from January 23rd, January 24th, and February 24th of 2023. They want to suppress the cell phone data that they acquired with the USB file from the Moscow Police Department Forensics Lab from a warrant January 9th of 2023. They also want to suppress the AT&T first warrant for his service. Okay. They also want to suppress the actual arrest warrant of Bryan Kohberger. They want to suppress his Apple account, which was given a subpoena by the federal grand jury, and the search warrant that actually allowed it for the Apple account, which gives a lot of information, that was done on August 1st of 2023, which would include his iCloud. Are you all just like, are your ears perked up? Mine were. Mine were. They also want to suppress the search warrant for the defendant's apartment. They also want to suppress his Amazon account that a federal grand jury also issued a subpoena for on April 26th and May 8th of 2023. And we're going to get into why that's going to be an issue. An Amazon account can also give a lot of information. Yeah. Okay. But more than that, the basis of all of this is they want to suppress the genetic testing that was done, the IgG, the investigative genealogy testing that we've already had so many motions on in the beginning, and Judge had to go over all of that information that was provided by the defense. We had witnesses. He received tons and tons of information, okay, on that. And they had already previously tried to suppress the IgG. Okay. Well, here we go. Now, for those of you IgG testing, well, let's just get into it. This, hope you like my voice. This is going to be a long one. Okay. So basically, in all of these, Mr. Kohberger has argued in a separate motion that the genetic genealogy investigation in this matter was done in violation of the Constitution. That's right, constitutional rights. Additionally, he has argued that there would be no investigation into him without that original constitutional violation. Now, we're going to get into the details later on what that actual violation is said to be. It is not that the results of the IGG sped up the investigation. Instead, they, meaning Moscow police and the federal FBI, actually, remember, this was a state police, local police, and FBI investigation from the start. It is not that the results of the IGG sped up the investigation. Instead, all of those organizations, focused the investigation on Mr. Kohberger, a person whose only connection to the case was his mode of transportation and the shape of his eyebrows. Two identifications of little to no value. As previously argued, as the Idaho Supreme Court has explained, while the initial burden in showing a factual nexus between the illegality of the evidence, yes, they're actually saying it was illegal, the state must show it would have been discovered anyway. State versus Moss. The state cannot make this showing. Without IGG, there is no case. No request for his phone records, surveillance of his parents' home, no DNA taken from the garbage out front, because the IGG analysis is the origin of this matter. Everything in the affidavit should be excised. Yep. They're saying that the way they did the family tree analysis was illegal. Well, let's get into it. There's more. There's much, much, much more. Yes, Juju, I agree. I totally agree. Juju says, what I am hearing is that the state was very careful about what they put in the affidavits, just enough to get them, not enough for the public to learn much. And that is true. And that is true. So there is a motion amongst all of these for a Franks hearing. Okay. Now, a Franks hearing is going to determine whether the affidavit by the Moscow Police Department Officer Payne was enough to actually go forward. And a Franks hearing, just for those of you that need clarification, is a court proceeding where a defendant, Bryan Kohberger and his team, can challenge the validity of a search warrant by arguing that the police officer who obtained it, in other words, the affidavit by Sergeant Payne, provided false or misleading information in the affidavit used to establish probable cause, essentially allowing the court to examine if the officer lied to secure the warrant. This legal mechanism is named after the landmark case Franks versus Delaware, which established this right to challenge a warrant based on false information. And also, not just the warrant, but everything. So the defense team is asking for a Franks hearing from Judge Hippler to go over all of this. Now, in a Franks hearing, it's reversed because the defense has to show that they did that. They have to show evidence to the judge that that actually occurred. Okay. In one thing that I will give to you, for those of you that like to read, we are not going to read this directly, but this is on file, Payne's affidavit. And we're going to discuss certain parts of it, but I'm not going to bore you by reading the whole thing right now all over. I will just say that everything that they did in regards to that is all listed carefully. And that some of the argument in the motions by Ann Taylor, and she did all of these. Remember, Langston actually did a lot of the death penalty stuff, but Ann Taylor actually did these herself. And she had to do them quickly because the day before, on the 13th, she actually filed a motion to Judge Hippler to try to delay discovery, the motions to suppress and get another date because the deadline was the 14th, which is why all of these were filed around 5 o'clock on the 14th in the evening. And they're kind of cut and paste. They all have the same thing, but they're getting them on record. And it's my humble opinion that this isn't going to go much farther except for to give possibly a grounds for appeal at a later date. Just to lay the groundwork, so to speak. Because, well, as we get into it, you can agree or disagree, but I do look forward to your comments because I'm keeping this under my hat for the last few days. It has been kind of tough. It has been kind of tough. So that is actually the pain affidavit that got us the warrant. Okay. Back. So key points in a Frank's hearing is we got to keep in mind the purpose is to determine if the police or this court or any of the organizations knowingly or recklessly included any false statements in a search warrant affidavit, which could lead to the suppression of evidence obtained during the search, or an illegal act like getting IgG testing done. Okay. When it occurs, this hearing typically takes place after a search and seizure has already happened when a defendant files a Frank's motion challenging the warrant. Key points are the burden of proof. The burden of proof is on the defendant. The defendant must prove that the false information was material. In other words, one of the claims is that in the affidavit, Officer Payne actually cut and paste something from another officer's statements and then was listing it as if it was his, but it is material fact, but it doesn't make any difference like who said it or who found it. But they're actually making a point of it that he may have misrepresented it by not documenting like who exactly said what. You have me for shorthand, Pete. I hope so. But this is a long presentation, and this is about as short as I could make it. But thank you for the compliment. Anyway, so now the defendant has to establish that it was not only that it happened, but that it's material, that it actually would matter to a grand jury on whether or not they issued the probable cause for the warrant. I don't really think whether Officer A or Officer B or Officer C said or documented something is actually going to be that big a deal, at least not to me. But hey, I'm no lawyer, just a bear reading files, right? But to me, common sense. If the material fact is that it happened and the evidence was discovered or they led to a thing, who does it matter if A, B, or C said it? Seriously, facts of the matter, right? That's what I'm thinking. Facts of the matter. Like, this is just, we're throwing spaghetti at a wall here. But I do see some of the groundwork that has to be considered, and we're going to go over. I want to give it the fair shake because there's some things here. So the potential outcome of a Frank's hearing, if the court finds that the officer or institution or whatever intentionally misled the court, the evidence obtained through the search warrant may be excluded from the trial. If the IgG gets it excluded, we have some issues. Okay. So let's go over how Bryan was arrested. Okay. Now, this is all going to matter in the long run, so bear with me. The identification and arrest of Bryan Kohberger in connection with the November 2022 murders of 4 University of Idaho students involved a combination of traditional police work, cutting-edge forensic science, IgG, and cooperation among local, state, and federal agencies, that federal agency being number 1, the FBI. Here's a detailed outline of those steps. The crime scene processing. Moscow police discovered the crime scene after a 911 call on November 13th. Evidence, including blood and physical items, were meticulously collected. They gathered witness statements. Interviews with surviving roommates, neighbors, and friends began immediately to gather any insights. Big arrow there. Testimony from a roommate. Bushy eyebrows, saw someone in dark clothes. How tall they were about 5'10", 11, they said. Dark clothes, wearing a mask to cover most of their face, went out the door. And they got a footprint outside the door. Okay. To corroborate the witness statement that someone was actually standing there. Okay. Public tips and leads. The police issued a call for public assistance. This is how they started to gather video cams, door, ring cams, neighborhood surveillance, you name it, including businesses, like everything. Public tips and leads were actually, this was a very volatile case in the area. Everyone was upset. Everybody was involved. Okay. They were looking for any information about suspicious activities or persons. Forensic analysis, DNA evidence. Investigators recovered DNA from the crime scene, including from a knife sheath found near one of the victims. The DNA was preserved for analysis and eventual comparison. They also had the autopsy reports, confirming the victims had been stabbed multiple times, providing insights into the potential weapon and an attacker's behavior, maybe even motive. Multiple times is pretty personal. Just saying. All right. The knife sheath. This we've heard about over and over again as the most compelling piece of evidence. The DNA on the strap of this knife sheath. Just a drop. Just one. Not a lot. Not a lot. And I'll just say, they also went for vehicle and surveillance evidence. The white Hyundai Elantra surveillance footage near the crime scene captured a white Hyundai Elantra. This became a crucial lead as investigators worked to identify its owners. So here's the three-piece components: DNA, a witness statement, and a vehicle in the area. That sounds pretty good to me. Okay. Then they start with database searches. Law enforcement searched vehicle registration databases, narrowing down possible owners to Bryan Kohberger, whose vehicle matched the description. Now, Bryan Kohberger wasn't the only one who had a white Elantra a white Hyundai Elantra. But in Idaho, the list was smaller. Now, the reason that they're saying Bryan Kohberger here, they're not automatically saying Bryan Kohberger. That comes a little differently. They also went and looked at cell phone data. Authorities animal cell tower pings to track Kohberger's phone. This was all before this was when they had him as a probable cause and they went for warrants and searches before the arrest. Okay, pings to track Kohberger's phone movements. This placed him near the victim's residence on several occasions before and after the murders. Behavioral profiling based on his criminology background and the calculated nature of the crime. Investigators considered Kohberger a person of interest. Why wouldn't they? This is where it gets DNA identification. Genetic genealogy. A familiar DNA match was conducted using public databases. This narrowed the search to Kohberger's family. And they eventually got a confirmatory DNA match. Investigators collected trash from outside Kohberger's family home in Pennsylvania, and that DNA from this trash matched the sample found at the crime scene. They then, after arrest, in furtherance, they did actually get DNA at the arrest. They got a swab, which was confirmed by the prosecutor's office to match the DNA. They had been tracking Kohberger. Authorities tracked Kohberger's movements across country as he traveled from Pennsylvania to Pennsylvania for the holiday. He was arrested on December 30th of 2022 at his parents' home in Pennsylvania following the issuance of an arrest warrant. Now, legal and procedure steps. Extradition to Idaho. He waived his right to extradition hearing and was transported to Idaho to face charges. Okay. And interestingly enough, in the motions to suppress, they're also saying that all of the statements, they want the arrest actually thrown out, and they want all statements he made to the authorities at his parents' home and during the arrest process without an attorney thrown out, which means there's a lot more evidence here than we thought in the first place. If they're going this hard to get everything thrown out, I think maybe they're worried. Now, they could be worried that it could look like he's guilty. Because let's be honest, if you get enough evidence, you can make a string and connect dots. Okay? Yes, you can. And the further they look in the deep, they're going to be able to turn stuff into stuff. I mean, remember all the hype about him being a criminology student? Like, that doesn't make you a murderer. Okay. You need more than the fact that he attended college for criminology. I get that. Okay. But it seems like they're worried about how all the dots are connecting. And apparently, there's a hell of a lot of more dots than we were aware of. Okay, that this case is not really open to the public. It's regards a lot of stuff has been redacted. A lot of stuff we're not privy to, and a lot of the actual motions to suppress the IGG and the arrest, the affidavit of pain, are actually under proper. We can't see any of it because of judge's ruling to keep all of that under seal. Okay, so anyway, long end of the story, he's now charged with 4 counts of first degree murder and 1 count of burglary, and these legal proceedings are ongoing. All right. But in that probable cause warrant, and this is just my common sense, okay? They had a drop of blood. They didn't get a Kodak's match, which is the regular police system that they use, okay? So then they submitted it to the public databases. And this is where the defense is focusing getting everything thrown out. The fact that they submitted to the public databases for identification. Because when they did, they used a familiar match because Kohberger family relatives were in the database to create a family tree, which narrowed the search. And once they had the name Kohberger, if the name Kohberger is appearing also on the motor vehicle searches for registration, okay, and in the universities in the area, okay, or anything else, if the Kohberger name came out, it does narrow down the pool, okay. In searching, I recall reading articles in the search for the owner of the Hyundai. They also got police records of people that were pulled over for traffic things with a white Hyundai Elantra, which matched to the Kohberger name, specifically to Bryan Kohberger. Okay, so there were things that actually linked together here. And then when they actually saw the license of Bryan Kohberger or saw the video of him being pulled over or actually pulled him over themselves, the witness statement comes in with the bushy eyebrows, the basic non-athletic but built, and the height and the bushy eyebrows. Why wouldn't this all come into play? It doesn't sound like it's fluff to me. It sounds like pieces of a puzzle being put together. It's not this standard law enforcement procedure in why does Ann Taylor think that the law enforcement officers aren't allowed to actually do their job? I think some of this is a little bit petty because it's not violating a person to assume like just to say, hey, I think I'll put you on the list. You do kind of match the description that the witness gave. Like, and your last name's the same as the familiar tree. Like, why wouldn't I look at you? I'd be really dumb if I didn't. Sorry. Person of interest, automatically. It makes common sense. It's common sense to me. Uh-huh. Anyway, the white Elantra is seen in the video footage in the neighborhood at the crime scene area. This is not all privileged information, and this is not a violation of anybody's rights to do a police investigation. It's not. A crime was committed. What's that saying? Yo, my rights end where others start? What about the victims? Their rights to justice. We got a right to look at you. We got a right to investigate. We are obligated to investigate. Yeah. Anyway, this is the part that gets me in all of these. Okay, this is one of the conclusions from the actual documentation. Okay, Mr. Kohberger requests this court suppress all evidence obtained by police via the warrant that permitted them to arrest Mr. Kohberger. As explained above, law enforcement failed to knock and announce before raiding the home, and the warrant lacked probable cause as written, meaning, plain statement, giving its heavy reliance on conclusions reached by law enforcement without the details necessary for the magistrate to draw its own conclusion. In other words, the grand jury, the judge, they didn't know because they didn't have enough information. And because the warrant omitted exculpatory information and information that put into question the reliability of the facts upon which it relies. And finally, because the affidavit relied on evidence gained in violation of the Constitution, all in violation of the Fourth Amendment and Article 1, Section 17 of Idaho Code. And we're going to go over those. Now, of concern to me is the knock and announce before raiding the home. Now, when they have a home, okay, they can, they knock and announce, and they, you answer the door, whatever, then they don't break the door or they don't do whatever. Okay, well, we have to understand the situation here. They understand that Bryan Kohberger's in the building. They also understand that there's four. We're not talking one murder, not talking like could have been an accident. We're talking multiple stab wounds. Okay, four people dead in a breaking and committing another felony, which was the burglary. Okay, like this was absolutely serious, and so it's not that uncommon that a SWAT team is sent for the search or the arrest. Okay, and it was at this point they already had the arrest warrant. They knew they were going to search the property. They knew they were going to arrest him. Okay, now this could go either way. There's plenty of case law that I saw by multiple lawyers pointing it out that failure to knock and announce doesn't automatically get anything thrown out. It all is about context, and it's all about circumstance, and it's all about like that's not enough to throw this whole thing out. Okay, and it's going to, if it does, it would throw out anything that they gathered inside the home there. Okay, and we'll see. Okay, but it is does throw a little bit of shade on the actual procedures if it was actually, but they're going to need body cam footage to show that. They're going to need testimony to show that. They actually have to prove that. They cannot just put it in a conclusion or put it in a motion and not actually prove it to the judge before he rules on it. By the way, Ann Taylor, have you met Judge Hibbler? This isn't going to go that easy. Not from what I've seen. I don't know what you guys think, but Judge Hibbler, well, he don't like to waste a lot of time, and he likes to stay on schedule, and he don't like no shady business. Anyway, this is how serious this is. Look at this. If they throw out IGG, fruit of the poisonous tree, everything goes away. They got the name Kohberger for the family tree and narrowed their person of interest search based on the IGG. That's a fact. That happened. There was no matching codex of the DNA, means no criminal DNA had been, or victim DNA to identify. And so they went to public databases. And I got a lot to say about that too. I've got some information for you on that, but I want to go over this part first. So if those are the questions, I definitely am going to get to it. So just hang in there. Yes, Pete, there are actual conversations. There are articles and statements from witnesses and other students and even like other people at the college that he was playing with law enforcement, driving around in such before and after and getting pulled over a few times. They are saying that he did go back to the scene after. And it could, and there was a lot of speculation in articles. So this is all coming from articles because it's not in court documents that I could find. But that he wanted to be in law enforcement. He had a fascination with criminology. He was, and that there was some theory about him testing out, how this whole system works. He is not your average suspect. I would agree. He's very calm in court. He's working diligently with his defense team, and they are clearly throwing everything they can at this case to get it to go away, to prove that nope, you can't just say I did it. You got like nothing. And there are some issues. We have talked on my streams before with you guys in the chat and with people on the back of the comments, the lack of blood evidence against Bryan, the lack of blood evidence in the vehicle, anywhere, clothing, anywhere, finding any kind of blood evidence or his DNA besides that one spot. Well, it's perplexing to me. Okay. So I don't know. But to throw all of this out, the Google searches, the Pennsylvania NEID searches of the home and his person and all of his statements, the arrest itself, statements he made, the pen trap device and location device information they use, AT&T service records, his cell phone USB file drive, the Amazon records, the Apple records, which could be quite like almost everything you do. What I mean, if you think about your iPad, and for those of you that are interested, when it actually came to the Amazon part, um, lawyer, did a stream today and actually read Amazon's terms of service and their privacy agreements and everything, and how you have to opt out of certain things because it's all there, how things get recorded, how the things works. Because if Ann Taylor's going to say that actually having an Amazon search warrant is a violation of somebody's privacy, well, that person signed up for Amazon and these things are all written out in black and white. What's going to be there? You don't want it there. There's certain things you need to do. Same thing with Apple. Okay, so it kind of goes both ways. And lawyer, actually read that one and went over all of the stuff about Amazon and all, because it is one of the more interesting parts about where's our privacy end. Like how much do we actually give away? That's a very interesting part of all of these filings. Not that they intentionally wanted that, but a very interesting part to me, because it does, like, where is that? This is a gray area, a complete gray area. From what I can find legally, it's going to go down to the terms of service and what actually he doesn't really have an expectance of privacy. Now, some say that he doesn't have an expectance of privacy to challenge the warrants in Pennsylvania, but actually he does. It's his parents' home and he was there and they knew he there, and he does. So like, that's moot. Like, he can challenge those things, even though it wasn't his home. Okay. He can. The rest of all of this belongs to him. His parents' house, not so much, but the rest all belongs to him, and he has a clear right to challenge. But there was some talk back and forth on the socials and in articles about whether or not he clearly does. I mean, that was clarified by another attorney, a couple of attorneys, in what I found to be probably the best actual breakdown of these by attorneys was on Law and Crime. You guys know I go to them, but it wasn't Mr. Weber this time. It was Angeline Levy, and she did a great job. She had a lawyer on there who actually explained some of these issues, just simple language in black and white, really concise, and I matched up to all the research I had already done. So I'm going to give you the video, because like, you guys don't want to go and read all that research, do you? Yeah. No, you don't. You actually don't. Believe me. Okay. So let's get back to this IgG testing. Okay. Investigative genetic genealogy testing has been primarily used in Idaho cold cases, solving decades-old murders. I mean, that's what they do. Its application in this investigation, like Bryan Kohberger, raises questions about its use in more contemporary settings and its role in shaping legal precedent, because it's not often used that way. In Kohberger's case, IgI played a part in identifying the DNA that linked to his family, but not directly cited in affidavits or warrants used for his arrest, because what they got from that was a last name. They didn't get a person, they got a last name. This highlights how the technique supplements but does not always stand as primary evidence. They're not listing it as primary evidence. They're listing it like a lead. Like as if you talk to the cashier someplace and say, somebody who matched that description was in here at about 10 o'clock. That's not necessarily evidence, but a lead. It gives you a time frame, and maybe that person was there, right? I mean, this is how I'm thinking about it. Is that actually evidence? It's a lead. It could come up in court later, but it was a statement and a lead, and it's documented by an investigator on the case, right? So why wouldn't the lab send it in and get this? Okay. Recent cases in Idaho and elsewhere have begun to test the legal boundaries of IgG, particularly concerning privacy and constitutional rights. Courts are evaluating whether defendants can challenge the use of IgE on Fourth Amendment grounds, especially since DNA left at crime scenes or submitted to public genealogy databases may not hold the same privacy expectations. Do you really have Fourth Amendment rights in the committing of a crime? And are they are allowed to investigate everything that's there? Point. No, like no. Bryan Kohberger can't say, well, I left my blood there, but I have a right to privacy. You can't touch it without my permission. That doesn't exist. And I know that sounds like a really crazy statement I just made, but that's how absurd putting Fourth Amendment rights on a crime scene is to me. Okay? That's how I look at it. You may disagree. I'm thinking that's just bizarre. Also, these DNA, these actually public genealogy sites, they have terms of service. Most of them you can opt in or out for law enforcement to automatically be able to use your DNA. Yes, they do. And the ones that are more commonly used by law enforcement, most of the people, when you put the search in, it wouldn't come up if they opted out. The Kohberger family tree did not opt out, or at least not enough of them, because we still got the name. This is a tough battle for the defense, in my humble opinion, not as a lawyer, just as one of you who love this kind of stuff. And maybe I'm a little more obsessive about the reading of the documents, but begs me to bring up the question on if they said that law enforcement can use it, then where's the issue, Miss Taylor? Where is the issue? This issue was focal point in the Kohberger defense team's arguments before and currently, as they questioned the methodology and sequence of events leading to his identification. Remember, we've already been down this road with Judge. Remember? And he said, I need a whole months to go over all this information because I don't even understand how this IgG works. The specific genealogy platform used to identify Bryan Kohberger through family DNA has not been publicly disclosed, nor should it, because it would interfere with people actually allowing law enforcement to use it. It could cause problems with the site itself. And it's for the benefit of all the general public and the case itself that they don't say where they submitted it to. Not publicly. This is why everything's sealed. Okay. It is known that investigators have used genetic genealogy methods, which likely involved uploading crime scene DNA to public genealogy database that allows law enforcement aspects such as GED match or family tree DNA. These are the two most commonly used in law enforcement, and they have opt-out clauses that if you don't opt out, law enforcement can, without a subpoena, use the DNA for a match. So, crime scene details of the genetic genealogy process in this case. Crime scene DNA was recovered from a knife sheath found at the scene. This DNA was uploaded to a database that supports genealogy searches to identify relatives of the person who left the DNA. Based on potential matches of distant relatives, genealogists and investigators built a family tree to narrow the suspect pool. This sounds all like investigative technology. Investigative methods to me. Direct DNA match. Once Bryan Kohberger was identified as a potential suspect, a confirmatory match was made using DNA collected from trash at his family home in Pennsylvania, which they had a warrant for. Yada, 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 yada. Right? So, Ann Taylor says, nope, I'm contesting that you even did IgG. I'm calling you on the exclusionary rule. And the exclusionary rule prevents the government from using most evidence gathered in violation of the United States Constitution. She's claiming fourth rights, that if Bryan Kohberger didn't know that he was going to be compared to family data, that you violated his privacy here. Like the nerve of you. Even though the specimen that is used for comparison was taken from a crime scene. Do you see why I think it's absurd? Okay. The decision in Matt versus Ohio established that exclusionary rule applies to evidence gained from an unreasonable search or seizure in violation of the Fourth Amendment. She's trying to say that if the IgG method was illegal to use to do that, to actually narrow the suspect pool to identify Bryan Kohberger, then everything in the affidavit to get the probable cause warrants for every other warrant that exists is moot and it all goes away. Assume that the primary and perhaps sole justification for exclusionary rule is deterring police misconduct. Did the police or the FBI or the forensic lab, whoever it is, in submitting the DNA found at a crime scene legally, submitted it to the IgG technology, was that illegal? How is investigative techniques illegal? Last I saw, we're allowed to lie to them. We're allowed to put them in situations where they have no choice but to tell us the truth. You get a lot of leeway in law enforcement for this kind of thing. If it was part of the investigation, they're not using it as definitive evidence. The reason it's not in the affidavit, if it's not definitive evidence, it is part of the technique that was used to narrow down the suspect pool. That's like saying the pen and paper that the police officer uses in collecting a statement, if it's not regulation grade, is illegal. I mean, that's how absurd this sounds to me. But there's no clear case law defining that this is investigative and not evidentiary. And that's the problem. So there is a loophole there. And Ann Taylor's grabbed it. And they are going to try again to get the IgG testing out, which they're saying if it was part of the investigation, it led to the release of the name or narrowing the suspect pool. That bushy eyebrows isn't enough. But bushy eyebrows in Kohberger is. You just line up the Kohbergers and the couple with bushy eyebrows, you start looking at. You know what I mean? I'm making that like jest, but this is not funny at all because this is a precedent-setting case. This will define IgG use in Idaho from this day forward. Whatever happens here, guaranteed. So what is the exclusionary rule specifically in Idaho? Pretty much the same. The exclusionary rule requires, actually mandates, the suppression of both primary evidence obtained as direct result of an illegal search or seizure, and pertinent here, evidence later discovered and found to be derivative of an illegality, the proverbial fruit of the poisonous tree, which we talked about. If they say the IgG search was somehow illegal or whatever, or violated his First Amendment rights, then, well, everything goes away. And based on the graph and based on the filings, everything means actually everything, except that spot of blood, I guess, which can't be identified. So Article 1, Section 17, which Ian Taylor mentioned, of the Idaho Constitution, prohibits unreasonable searches and seizures. It states that people have the right to be secure in their persons, house, papers, and effects. It also states that no warrant can be issued without probable cause, which must be shown by affidavit, which they did. What she's saying should be tossed out. She doesn't like the way it was written. Bushy eyebrows aren't enough. Identifying the vehicle aren't enough. And a match to a family tree is illegal. The affidavit must also specifically describe the place to be searched and the person or things to be seized. There is some clarification on, like, there are broader warrants, what they say, like what they're looking for. They might just say evidence in regard to linking to the crime or Bryan Kohberger's actual possession of items that link to the crime, whatever. There could be broader statements. A lot of times they don't list everything that they're looking for because often when they're doing a search, they don't know exactly what they're looking for. They're looking for anything that is going to lead the investigation to what happened, why it happened, how it happened, and who did it. Right? So let's get into the Fourth Amendment part. Have I lost you yet, people? I hope not. This right, Pete? Like this one, Pete just made a comment. He said this Kohberger case goes well beyond much other cases. It sure does. This one is stretching my brain. It is stretching my brain legally, and it's tickling my fancy on how I like to follow cases that will actually lead to precedent in changing law and new statutes in actually, be the cases that we list that get listed in motion after motion from here on out. And this one's going to be one. This one definitely. Right. So with the Fourth Amendment to the United States Constitution, it protects its citizens from unreasonable searches and seizures by government. And absolutely we need it. Okay. No one should be able to come up under law enforcement and just stop me on the street and do a search and seizure or whatever because they feel like it. They need to say why. Okay. The official text of the Fourth Amendment is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. When warrants are required, warrants can only be issued upon probable cause. This makes sense. You cannot just say, I want to search that person. You have to say why. And you have to prove to peers, a judge, or a grand jury that, supported by oath or affirmation, your statements must particularly describe the place to be searched and the persons or the things to be seized. They have to say what they why they're going to be there, why they want to search them, who they want to search, why it's reasonable to go there, and what they could possibly have there. They could have listed stuff like any electronic devices, any papers, receipts, anything that would indicate, anything that could be used in the perpetration of the crime. Okay. Remember, they were still looking for a murder weapon, right? Okay, why is not going forward? Here we go. Hey, come on. Oh, sorry, guys. It just went all the way back. It doesn't want to behave. When the Fourth Amendment applies, the Fourth Amendment does not guarantee against all searches and seizures. No, but only those that are deemed unreasonable under the law. Keyword there, unreasonable. That's going to be up to Judge Hibbler. Factors that determine protection. The extent to which an individual is protected by the Fourth Amendment depends on the intrusion of their rights and legitimate government interests. I'm going to bring up another case here. When you're in prison, you have no Fourth Amendment rights. They search your stuff regularly. You don't really own anything that's in there. They could take it away, contraband. They could do it. You have no right to privacy. Okay. There are certain situations. If you are being held in a mental facility with no personal rights, the Fourth Amendment, as far as privacy, they're allowed to search your body, make sure you can't harm yourself. They're allowed to take all your possessions. You see what I mean? Like there are situations where Fourth Amendment doesn't apply. Okay. Not so far here. Like he wasn't in jail and he wasn't in a mental facility. I get it. But was it unreasonable? Okay. All right. So with all of that being said, and that was a lot. Let me just take this down, put myself back up. Hey, I'm all big again. And I want to go over these comments because I know you've probably been commenting like crazy. And I have more things to share. Muffins for I need a muffin, Juju. I hope you're serious about that. I do. I'm going backwards up here. Yeah. Hey, Jen. Good to see you. I am not wrapping it up. I have one more thing that I want to share with you in regards to George Hibbler. But I want to check the chat for comments first. If there's one thing that Claire loves, it's a precedent-setting case. You know me well, Juju. You know me well. Yes, exactly. This is kind of how it all reads to me, Juju. And this is the point I wanted to make. It's like anything that made you even look at our client, like our defendant, let's just get that all out of here. Let's just like close this done dusted case over. Like, no, the word Kohberger shall not be mentioned. Like, nope, who don't know. Well, however you got there, nope, let's get rid of it. Exactly. Now, that doesn't mean that they shouldn't look at the affidavit and make sure that, Officer Payne's statements do stand up and that, they should set the precedent on IGG because, well, if they find out that the Kohberger family tree actually opted out of this, and maybe they did this without permission or without a warrant, well, that could be sticky. Or if they decide that whatever information they use to acquire a warrant, because here's the thing, this is all sealed. We don't know if they had a warrant to do it. If it's public access, they don't really need one if the people didn't opt out. Hmm? I don't know. Neither do you. They have it all sealed. But there's going to be a hearing. I don't think that Judge Hippler has any choice but to schedule this Frank hearing. He may not schedule a separate hearing. He already has one scheduled for January. We'll talk about that in a bit. This is right, Pete. I'm not a lawyer. I just like to read like legal stuff. You know, Pete, this is true. We did give these up, whether we wanted to or not, with the Patriot in company passed 20 years ago. In other words, for security of the people of this country, we did give up some rights to where government officials can actually come in and violate our Fourth Amendment rights to privacy for the greater good. Is that what you're talking about, Pete? And we're talking about Homeland Security. We're talking about the issues of 9/11. We're talking about how Fourth Amendment rights were violated all over the place, but it was for a purpose, and that Patriot Act stuff was definitely valid 100% all the way. If it's for national security, you know, don't be expecting to be saying, hey, you know, when Homeland Security comes to get you, that you're going to be going, hey, wait, I think you're violating my Fourth Amendment rights, and you think you're going to get anywhere, because you're not. You're not. Okay. They did. They did have his DNA. They had to drop the DNA from the crime scene. Thank you for picking up on this, Pete. Because they had the DNA prior to doing the IgG thing, they had evidence at a crime scene that somebody's DNA was there. Are they not obligated to do investigative technology to find out whose it is? Sounds reasonable to me. I don't find that unreasonable search. I don't find that unreasonable method. It's because it's new. And I've got so many cases with new technology with DNA. The one from New Jersey, I'm going to bring up maybe at the end of this week by video, by whatever, is so fascinating because, again, first time ever used in the state, precedent setting, new technology. But, you know, technology doesn't always, you know, keep up with law. And it is, I will say this, it is the defense's obligation to challenge it. She's doing what she needs to do here. She's doing a good job. Be being a little about it because I see some like wow in the statements, like, really, you going there? Like, good try, but I don't think it's gonna wash. But that's just because I can't, because I'm not a lawyer, you know. I'm just like you guys, I'm just looking at it. But let's be clear, she's totally doing everything she should do. And Bryan Kohberger has an excellent defense team. Excellent. Okay. They're killing trees as they should. They are actually doing everything they possibly can to make sure he gets a fair and just trial and that his rights are not violated. And why not? Why not leave it up to the judge to decide? Right? On that, I've got something for you. So, remember I'd mentioned in the beginning that, well, Miss Taylor had filed that she wanted an extension on filing all these stuff for suppression and discovery. And well, Judge Hippler answered her immediately. Let me put this up there for you. Let me take that down. And we're going to go over this tone a little bit here. Okay, order denying motion for leave. She wanted a motion to leave to extend the deadline of November 14th for these filings. Okay. Before the court is defendant's naked motion for leave on November 13th, in which he seeks relief from the discovery motions deadline of November 14th, as set forth in the governing schedule order, which has been out for quite some time. Defendant asserts his counsel and investigators are still reviewing the vast amount of discovery in this case, and therefore he needs additional time to file motions related to discovery. Motions to enlarge a deadline filed on the eve of the deadline are not well taken. The state's discovery deadline was September 6th. Defendant could have ascertained far sooner whether the discovery motions deadline would pose a difficulty and brought it to the court's attention. Further, and importantly, defendant has not demonstrated with his filing good cause to enlarge the deadline. He has not set forth what efforts have been made to review the discovery, what portion of the discovery has not yet been reviewed, why it has not been reviewed, or how long it will take to complete such review. Consequently, this motion is denied. I think Ian Taylor just annoyed George Hitler. Anyway, but I read that because I want you to see what exactly Ian Taylor is up against with George Hitler. And I have something else for you. Oh, Andrea Burkhart. Oh, first, I want to give you, in regards to the affidavit that we were talking about of the law enforcement officer Payne. Okay, there is from the actual. Hold on, I'm going to pull it up in a second. I'm giving you links to what the statement that I'm reading here, and this is from the NCJRS library, the U.S. Department of Justice, Office of Justice Programs office. This is from the Law Enforcement Bulletin for the FBI. It's what they use, okay? And this is about misstatements and affidavits for warrants, Franks and its progeny, about that process, okay? So the abstract of it was the Supreme Court made it clear as early as 1933 that simply officers acting pursuant to a warrant does not insulate evidence seized from being suppressed if the facts presented are deemed insufficient by a reviewing court to establish probable cause. And this was Nathanson versus the United States way back then. The principle that a warrant can be challenged after its issuance was later relied upon by the court to invalidate arrest warrants as well as search warrants. After Mapp versus Ohio made the exclusionary rule applicable to the states, it was similarly relied upon to strike down warrants in state cases. In Ruckendorf versus the United States, the court held that inaccurate information in an affidavit, which is not necessary to a finding of probable cause in which does not impinge upon the integrity of the affiant, will not cause a warrant to be invalidated. In Franks versus Delaware from 1978, which is where we get Franks hearings, the court made it clear that only where the defense has proof that the affiant lied or acted with a reckless disregard for the truth with respect to some material statement in the affidavit will a hearing regarding such be required. A deliberate falsehood by a non-affiant fellow officer may fall within the Franks rule, but an informant's misrepresentation will have no effect on the validity of the warrant. In other words, if the officer files everything correctly, but a statement made by somebody else is not, you can't hold that warrant as invalid based on what he said, what was put in it. To be guilty of reckless disregard for the truth, the officer must have entertained serious doubt as to the truth of the information inserted in the affidavit. The post-Franks decisions express due regard to the confidentiality of the informants, and officers should note that courts may require an in-camera hearing to ensure the existence of the informant and the fact the officer has not represented the informant's information and echo. And then there are a whole PDF of articles and everything written from that was like, nope, there's not a screen share on it. Oh, I forgot. Oh, sorry. It didn't pop up. Damn, StreamYards got me again. Sorry, and thank you, Juju, for letting me know. Okay, but anyway, I read it. That's what it is anyway for the whole thing. And it is definitely coming from that document in the screen share did not, I don't know why, it has something to do with my internet, or StreamYard just didn't feel like cooperating, you know. But anyway, that actually is pertinent for you guys if you want. I'm sorry that you had just nothing but a blue screen there for that. Okay, so there is the PDF source that goes with the actual statements from that site. That site's very useful for looking up, how certain things are done in house, certain judicial types of hearings and all, and working with the FBI and investigative organizations throughout the United States, how they use the information, and what they're allowed to do and what they're not allowed to do, and the problems involved in it. It was very informative. The other thing that I have in regards to Judge Hippler was that Andrea Burkhart, when Judge Hippler was first assigned, there's an attorney in YouTube law out there. She has a YouTube channel, Andrea Burkhart, and she actually looked into Judge Hippler because, we knew him in Idaho because, like, in the Lori Vallow case, he was like higher up, and he was one of the judges they had to go to in regards to mental competency and some of the other things that was looked at in regards to scheduling and this and all. It was pretty high up there. So, but he's not a flashy judge, and we don't hear a lot about him. So she did a little looking into him, and this is her Substack article in regards to it. But basically, her conclusion was that Judge Hippler really is not a flashy judge. He's really into the law. He doesn't make decisions that are extravagant. He basically, follows the law. It's pretty safe. He's only been appealed. He doesn't get appealed. And that is an important thing here. So when he's going to look at this, he's going to look at the whole thing. Okay. And he does not get appealed. He doesn't make those kind of decisions. But we understand why the defense is doing that. They got to lay the groundwork for an appeal for after or for whatever. And also because for due diligence to represent their client to the best of their ability, they're going to have to look at everything. And because IGG is not that often used all this way, it is being used more and more all over the United States. Okay. It really is in other states. But there isn't a lot of precedent in Idaho for an active case. It's usually a cold case. Okay. And there's not much of a violation of rights when they don't have a suspect. Okay. They do use IGG technology to narrow suspect pools a lot. They do. It's just not in, an active case like this, a new case. You only hear about it mostly in cold cases because it was quite beneficial, because they have no DNA matches, but they have DNA. So why not? DNA technology is advancing every day. Okay. And the courts and the legislatively, and the court system, state and federal, really needs to catch up a little bit with the technology. It's not that unusual for someone to say, hey, is that a violation of anything? Although I don't really see how it is when I look at the whole picture, I do clearly understand why they would put it forward. It makes good sense, right? And if that was my defense attorney, I'd be very happy that that's what they're doing. But as the prosecution, I'd be a little bit annoyed that I have to go through all of this. But again, for me and some of you, it's quite exciting because it's going to set precedent, and it might actually put case law on the books that will actually solve this issue for future lawyers in cases, right? Yeah. And give them something to go with. At least a decision one way or another. So anyway, in Andrea Burkhart's summation for Judge Hippler, he's not very flashy. He doesn't have a big public presence anywhere. He doesn't. We heard him when he first got this case. He said, "I'd really like to tell you I'm happy to be here, but I don't want to start out on the wrong foot by misinforming you with not the facts." He's not happy to have this case. He actually approached the first hearing with a schedule on 20 minutes. You're going to talk about this. You're going to go over this motion. We're going to cover this. We're going to do that. Like, he's trying to get them in line and get everything, just like Judge Kranick in Brune's case, where he just took over and he was like, he just set down we're doing this, we're doing this, we're doing this, dot the I's, cross the T's. We're getting this off the books. No more delay, no more delay. Okay. Remember, this is scheduled for trial in August. Okay. It is scheduled in trial for August. The I believe jury selection starts at the end of July. And they know it's going to take a while. I believe the trial date is August 11th, 2025. Okay, so where are we now? We've got a judge who's already annoyed that Ann Taylor had the nerve to ask for an extension the night before the deadline, as if his schedule doesn't matter. The tone of that was what I wanted to get across to everyone. Okay. We already know that it's just not enough to throw it out just because there might be a misstatement in an affidavit. It has to be materialistically relevant to throw out the affidavit that got the arrest warrant, got all the other warrants from the grand jury, all of those that happened. Okay. Um, we can read that in the guidelines on how Frank's hearings are run. Okay. Um, they're just going to go over everything in January. We got January 23rd. Now, the prosecution has until December 8th to answer all of these motions, which I'm sure they will. And I hope they will put down something else about the use of the IGG. But there's so much that we don't know. We do not know um, a lot in regards to the IGG information that is even filed in the motions, that has previously been filed, that has been put before the judge by the prosecution. You know, I just, I am just, well, let's just say I'm looking forward to reading those too. At the end of the month, I would imagine we're going to have plenty to read there because I want to be well informed for the hearing. And yes, we are going to, if not put the hearing up live, we are definitely going to record it for you all because wow, is that going to be something? It's going to be some good lawyering and some good judging and stuff. Now we just went through the death penalty motions, the oral arguments in regards to this case, but we still don't have anything on Judge Hippler in regards to it yet. And he has time. He has time. I don't know if he's going to put that out before January or if he's going to tackle this first, but we shall see. We shall see. Basically, the only motion that we have approved so far is that Bryan Kohberger can wear street clothes so as not to look more guilty in front of a jury, and that's not unusual. And I think that's his right. He's not convicted yet; he's on trial, and so he doesn't have to wear the orange and look like a guilty man in front of a jury. And I agree with that. I don't know about you guys, but I'm all for that. I don't think that was a big deal. Okay, we also did get the trial moved to August. Okay, we need a D penalty on the table. I do, you know what? Here's the thing. There are 11 aggravating factors in Idaho that actually qualify for the death penalty, and the prosecution states that Kohberger qualifies for 4. It is the type of crime that it is, the violence that ensued, that it was exceptionally heinous, the amount of murders. There are 4. Actually, a burglary was at the same time. I mean, there were a threat that he could commit murder again. If you could kill 4 people in that time, the propensity that further murders could exist and a threat to others would exist is there. Those are the 4 that they listed. Okay. And yeah, they're listing 4. And and Taylor says, but it's not fair. During that hearing, basically, and the defense is actually saying Idaho has an issue with the death penalty. They had a problem with getting the medications for a while that are used. And then the last one with Creech, they actually couldn't get a vein. Okay. But Idaho actually solved that problem by instituting the firing squad as an optional method. So if you fail one way or you can't, we'll just use this one. Well, she actually said it was mentally cruel to let Bryan Kohberger sit on death row, knowing he was going to die and not know what method they would be using. Mm-hmm. Mm. Yes, exactly, Pete. It's not fair. And I'm curious I do not believe that Bryan Kohberger will accept the plea. Not at this state, not with these defense attorneys throwing everything they can at everything. I think even if found guilty, there will be appeals based on the death penalty, based on the IGG. And that's only reasonable just based on the two things. The death penalty is a controversial issue across the nation. It's not becoming very popular. It's argued all the time. However, as the prosecution brought forward, when she said it's not very popular, he said, "Oh, excuse me, but 27 states still allow it, which is more than half of our country, is all for the death penalty. And it has to get voted by the constituents of that state." So, well, Ann Taylor, not so much. Okay. Yes, there's a movement that it's cruel and unusual, and we really shouldn't do it. Eye for an eye is archaic, or whatever it is they say, and there's plenty of argument about it. It's controversial. So, like appeal, yeah, that's why the death penalty gets an automatic appeal. All right. And now with IgG technology used to limiting the actual with uh, suspect pool to actually narrow down persons of interest, that's a weighty issue also. So it's almost guaranteed there's going to be an appeal. 27 is your favorite number? Okay. All right. Let me look for questions. I'm sorry that I didn't have that document up for you guys. It must have been terrible to look at this blue screen for a little bit. I don't know why it didn't pop up. I don't see any more questions. So on that, I think I'm going to end it for the night, like a few minutes early, if you guys don't have any other questions. If you think of anything later in regards to all of this, hit the back of the video for me. Hit that actually while I'm talking the last couple of minutes, I can take Mippy's suggestion and put that banner up, because I hate the YouTubey things, like share, subscribe, all of that. Don't forget to hit me with your questions, comments about it, things you want to look into deeper. I tried to cover all the different elements of fairly the motions that were filed. I didn't go into great detail and read all of the motions because you guys can, and they are very repetitive. Okay. And I do think that actual checking out Lawyer video in regards to how they went over the Amazon policy in regards to information and everything was very valuable, because these opt-out things that we all see, a lot of, how many times do we sign up for a service and we just it says read the privacy policies and we just click, you know? It's good to kind of put it in context as to how that could affect you later for something like this. Them actually saying that the Amazon, they want everything gone because the amount of information that they can get from the Apple iCloud and the Amazon account alone, everything he searched for, everything he's into, the stuff he reads. Think about Amazon, the books you read, the stuff you search for, everything. Everything. Okay. And your Apple iCloud has everything from your phone, from your Apple accounts if you use computers or laptops, computers, and any kind of social device that you connect your Apple account to, it's there. So those rights to privacy, once you opt out, how far do they go? What's reasonable, right? Mm-hmm. Hey, welcome back, Liam in Rocket Couch. I just want to see the evidence so much. I know. And are you actually, Juju, are you surprised by the amount of motions to suppress in what they actually possibly could have? Now it's a bigger picture to me. It's the investigation was much more detailed, that they narrowed down a suspect so quickly. Okay, but this IgG is important because now they're not going to be able to say, well, you only looked at one guy and there could have been other people, because they had a valid reason to only look at one guy, or at least a smaller suspect pool. And I think that is why all these motions, I think that is why they're so hard on getting the IgG out, because then you can go in and reasonable doubt to a jury say the only person they looked at to solve this very violent, very horrible case in this area that had everybody upset, they were looking for a win. They found a guy. They're just going to put it all on him. They didn't do due diligence. They didn't look anywhere else. They didn't. They did actually narrow that suspect pool down pretty quickly. You know? If we're talking about the death penalty, it is not a deterrent. No, because first of all, the length of time it takes to actually do it is almost like you're there for life anyway. The threat does not work. Neither does life in prison. You know, I know a lot of people don't care about the studies, and I want honest and respectful conversation in regards to this, guys. Everybody can have their own opinion on it. You know, we've had death penalty conversations before, and there is actual two sides to the coin here, you know, is regards to cost, in regards to justice for the victims, in regards to the greater good in setting a precedent, um, in actually making it unacceptable or to do certain things. You know, I know some people just fall on the line of it's taking a life and say like two wrongs don't make a right. And I get that. I totally do. But there is more balance to it. And whether we like it or not, here in the United States, 27 states have voted for it and still make it legal. And it's going to be used and it needs to be used in those justice systems because that is the actual precedent there in that state. So it's a moot point to say whether or not he should get it or not here. They actually have to go through the process of it if he qualifies. They would not be doing their job for justice for the victims and using the penalties the way they should in that state. Right or wrong, and what your personal belief is in regards to the death penalty, that's how it has to be in Idaho currently until legislation's straight. And this is why Chad Daybell got the death penalty. Some people would want to sit there for the rest of their life detained in a cell, you know, just to have life, and others just like they did the crime, they want to go. But I do understand the studies. I do understand that there's a lot of push. I mean, we just went through that death penalty hearing and they made some great points about cruelty, about the studies, about all of it. But currently in Idaho, it's valid penalty phase, and penalty phases have to be met. And he doesn't just meet the criteria on one, he meets it on four. Okay. And so it would not be justice for the victims, or the prosecution would not be doing their due diligence in their job responsibly if they didn't put it on the table at this point. Think of that area when this crime happened, a university town that hadn't had a murder like this in 40 years. Everyone upside, still to this day, every coffee shop talking about it. People afraid. Okay. It was a horrible crime. 4 young people in their early 20s gone. Everyone who loved them, all of their families, everyone who went to school with them, who knew them. Okay. They are screaming for justice. And in the state of Idaho, the death penalty is part of that justice. So, like, I understand the argument back and forth. And I do actually support everybody finding it distasteful. I myself don't want to think about killing another individual. I do not. But legally, this is what we need to do. Legally, because this is how it is, and because in our country, we get to vote on it, and the constituents of Idaho voted for it. And not just a long time ago, recently. They got so upset about not being able to do the death penalty that they put the firing squad back on the table because drug companies were not actually willing to provide easy access to the drugs anymore, knowing what they were going to be used for. It is a touchy subject back and forth, but legally, this is what needs to be done. You guys know how I am about law and order. It doesn't always make things morally stand with what I'm gonna like believe personally, just like you guys in the chat. But I understand why they're doing it. It doesn't make them evil people. It makes them law-abiding citizens doing their job. So let's keep that in mind. Exactly. You know, they have to go through the process. They do. The outrage to the prosecution, had they not put it on the table when he fit for aggravating factors, would have been egregious. How could the families look like they were being served? Exactly. Yeah, we didn't. And the law enforcement did. And the families and the people that knew them are the ones like dealing without the victims, their lives cut short. Like it's just a matter of justice. Whether we think it's too harsh, whether they think it's unreasonable, it is the law currently. And until that changes, we'll just keep having these discussions back and forth, right? You know? Oh, well, that would be hard. Motion to dismiss the evidence that puts the death penalty on the table. That would be the 4 dead bodies, the act, the crime itself, Juju. So I don't know. It's kind of impossible. You know what I mean? I don't know about sympathy and firing squads. Like I'm sure that those are law enforcement officers of some nature who follow the law. And I think they would, I don't know if they have a choice or not, but it's something I can look into, Couch, because, that's something that didn't occur to me. I don't even want to think about somebody that has to actually do this. Like, I wouldn't want to. I agree with some of you. I also agree with the legality of it. So you could say that I'm on all of your sides in the chat. Like, I see it both ways. I do. Juju, I don't know if you're serious or not, but I agree with you. I think Ann Taylor has well more than another 100 pages in her. I don't think she's done yet. I don't. I absolutely don't. I hear you. I hear you. All I can say is this case is fascinating. I am not sorry I'm covering it. I know it's one of the more popular ones out there and everybody's covering it, but for me, it's still fascinating. These details, they make me they just they're keeping me intrigued. I like bringing it to you. I'm sorry it's so boring to just go over precedent and law and all of that kind of stuff. I definitely didn't want to read all of those documents to you, but I think I laid out what she's getting at. You know, they make you want to know more. Me too, Juju. Me too. Like I want to know eventually what is all. Yeah, I should think the selection for firing squad is a process where they. I think so too. I don't think people that are actually do it um would be doing it if they had the issue. I kind of agree with that, but like I don't know, so I can't really say. But also, Juju, I want to know so much more, especially about everything that's being held back from us, the actual IGG process itself and how they got there, what actually was done, all of the evidence that she's throwing out in regards to that we don't get to see. What actually is it that they have an issue with the pain affidavit, like the complaint, and I do believe I gave you a copy of that in there. But if you guys need anything else, go to the Idaho. If you want to read the 13 motions, they are all available on the Idaho site. They do because it's a big case. It's public record there, except for the stuff that's under seal, which is there's only 2 pages that ask for the Franks hearing. And when they go into detail on what they actually are accusing the officer of or the investigation itself, we don't get to see any of that. It's 2 pages saying it's all under proper and sealed as per this order, blah, blah, blah. That's it. We don't even get to know. So all I could do was explain the process for you and what will or will not get it thrown out. We've barely seen anything. Although today, aren't you a little bit happier though, Juju, that we actually know that they have the Amazon account, the Apple records, they have all of his cell phone, like they have everything, you know. Mm. You know what? Wherever it comes from, Couch, we're all entitled to how we feel in regards to the death penalty and the methods that they use. You know, all I can say is the defense is actually doing everything that they can for Bryan Kohberger in this case. Definitely, definitely excellent defense team there, really doing everything that they possibly can. And now we just wait and see what the prosecution is going to put forward and then what Judge Hippler actually does. But it should be interesting nonetheless. So, on that, I'm just going to say thank you all. I will most likely see you again this week because, you know, P. Diddy had a hearing today and he's got another one on the 22nd. And man, did that also Fourth Amendment rights violations, prosecutions doing things that maybe they shouldn't. And oh my, ay, ay, ay. We're going to talk later. And on that, thank you so much, everybody. And we will talk soon.